I've listened to the discussion with two Senators from Spartanburg and some of the comments being made, and I feel like I got to respond. First of all, and of course, I'm not going to be responsive to this outside group that's put all these emails out that I was blocking the bill and all that. I'm not going to give them any fodder for their next mail out soliciting funds, because that's what they do. The PS. I'm not even going to name the group. PS. Contact Senate Judiciary Chairman Larry Martin and insist that hearing on constitutional carry, Senate Bill 115, he's had it on the agenda for a year now, but not actually held a hearing. Help us spread the word by donating $10 or $20 today. That's the final paragraph of the appeal. But be that as it is, let me tell you, Senator Morey and myself were two of the members of this Senate, maybe the only two left in here that serves on Judiciary today, set up an all-night filibuster while the State House was under renovation. We talk about we got to fix this infringement on our constitutional rights, and this is the way to go about doing it, because that's your interpretation of the Constitution, and I respect that. But let me tell you the history. The history is prior to 1996, I guess it was, 97, whenever it was, when we set up an all-night filibuster across the street while the State House was under renovation. And your predecessor, Senator McClariton, he was wearing his tennis shoes, keeping us up, and he looked pretty fresh the next day. I thought, or the next morning, we actually got cloture on him. That's the only way we're going to shut him up. And, but I'll never forget, prior to that time, you want to talk about, well, what does that constitutional provision mean, Second Amendment? What has it meant? You know, you mentioned what the Supreme Court said it meant, and I respect that. We don't allow felons to own guns. That's an infringement. When they get out of jail, serve their time, that's an infringement on their right. If you're on probation, that's an infringement on their right. If it's a misdemeanor, generally speaking, they can't carry a weapon. Of course, we don't apply that to misdemeanor offenses in this state. But my point is, the history is, if y'all want to know, and I asked our able counsel here to look it up, I said, when did it really change? How long had it been that you could walk down the street without a permit, without a law enforcement commission? Because prior to that time, you had to have a law enforcement commission in order to carry a weapon on your person beyond the borders of your property. And I think Mr. Hazard told me it goes back to Reconstruction. That's how long it had been. We're talking about a public policy that had been in effect in this state for over 100 years, longer than anybody else, older than Strom Thurmond, senator from Charleston, longer than anybody else around remembers. So don't go telling me that we're all of a sudden infringing on our constitutional rights. We don't understand the Constitution, and we have to be re-educated on what the Constitution means and what public policy means. Let me tell you, we set up in that to give law-abiding citizens of South Carolina the right to protect themselves. I strongly believe in self-defense. I was a subcommittee chairman on the Castle Doctrine when it came through this committee. I've worked as hard as anybody to get people's right, law-abiding citizens, the right to defend themselves if they so choose. But I'm talking about law-abiding citizens under the concealed weapons program that on a permit basis is restricted to folks with clean criminal histories. This bill, if you own it, you can carry it. That means anybody, any two-bit criminal that's had criminal domestic violence prosecutions, DUIs, shoplifting, think of all the other categories, help me out, my legal friends, that fall into the misdemeanor.
Martha Stewart.
That fall into the misdemeanor category. I'm talking about less than a felony. I'm talking about what your bill would do to public policy. Less than a felony, you can carry a weapon openly if this bill is adopted. And I'm offended by that as a public policy matter. I'm offended by the notion, and no disrespect, I'm offended by the notion that all of a sudden, we don't know what the Constitution means. We got to be re-educated on what the Constitution means. I know what the Constitution means. We're not going to allow criminals to carry guns as a public policy. This legislature has had a pretty strong history of that. And I'm not suggesting that you're setting out to allow turn public policy on its head to intentionally allow criminals to carry guns. But in the day and age in which we live, unless you know that person, and I get it, I mean, criminals, a lot of criminals carry guns in their coat, in their pockets, whatever, but they don't carry them openly, which this policy would permit until such time as a law enforcement officer has a belief, a suspicion, that that person is either about to commit a crime or that person is indeed somebody he recognizes as a felon that would otherwise not be able. He didn't have probable cause, he can just walk right past him carrying that weapon openly. Now, granted, he may carry it concealed now, but he don't subject my family to it openly. And that's the difference, and that's the policy that I can't quite wrap my arms around. There's other things about the policy that, with respect, and I've had people tell me, they said, well, listen, I'd like for y'all, I like the training. I got back a bunch of emails. I like the training. I'd like for y'all just to, I think is a senator from Fairfield said, you know, and I think we need to, yeah, I want to call you something else, but I'm not going to do that. But put you at another location. But my thought is, when it comes to the public policy, this is something we talked about quite a bit. We even discussed this, Senator from Horry, if you remember, about carrying it on your side with the permit. And I had people suggest to me, well, why don't we do that? Well, there are a couple of reasons. As a policy matter, we don't do that in South Carolina. Some states do it. We don't do it. One of the reasons we don't do it is when you walk down the street, you see somebody openly carrying a weapon, you pretty much assured it's a law enforcement, that person's got a commission of some sort, some law enforcement officer of some sort. Otherwise, you'd be carrying it concealed. You recognize as a person out in the public square, not on your property. Now, granted, on your property, you can walk around all day long. That's the infringement is on your property when you start telling somebody on their property what they can do and what they can't do. I think that what we're talking about is out in the public square, and that's the difference. That's where I draw the line. And the other thing is the whole idea of when somebody puts their hand on something, you know, if it's concealed, the policy is it's concealed. And I had a law enforcement officer talk to me about it. He said, you just don't understand how the dynamics of that is going to change from a law enforcement standpoint, particularly when it comes to the invocation of self-defense. Because the minute a law enforcement officer puts his hand routinely on his weapon when he walks up to your car or he walks into a situation, I don't get overly nervous about that. But now, somebody who's not a law enforcement officer, he puts his hand on his gun and he walks towards you, it's a whole different set of facts. And if it's concealed, you know, he's got to reach for it and he's got to pull it out, and then that opens. There's a whole different set of circumstances that's going to apply, I think, in the public mind when it comes to the invocation of self-defense as it relates to to civilians who, by the way, get a little bit of training. They don't get all the training they need for self-defense, what constitutes the elements of self-defense and all those kind of things that our legal scholars in here, particularly the senator from Horry, has charged juries with, I'm sure, many, many times. You know, where you had a defendant that was arguing self-defense and he was arguing, no, it wasn't self-defense. This is what this fellow's on trial for. It's different. Those are the kind of things that's going to turn our public policy on its ear. That's why, at the end of the day, I come down on the side of our, you know, exercise your right to self-defense, have a strong right to self-defense under the Constitution, the right to bear arms under the Constitution, but let's do it with the CWP program that we already have 229 or 30,000 law-abiding citizens who are lawfully carrying weapons in this state. But with this, Lord only knows how many less than law-abiding citizens who could legally carry under the Senator from Spartanburg's bill. I can't buy that and all the changes it's going to make. And for that reason,